Sorry about that. I think I put my microphone on mute. Hello, everyone. Welcome to our first show. I'm gonna welcome my guest, Tony Lung Mai, to the show as well. Hello, Lung. How are you?
Hello, Lam. I'm doing great. How about you?
I am excited for this show as well. This is I think, a very valuable show that we are going to talk a lot of question about probate, specifically for Arizona State, I guess. But I think that I'm sure a lot of people have a lot of question about probate as well. So why don't you introduce yourself a little bit so that everyone know who you are and how can you talk about this?
Well, first, I just want to say thank you for creating this show and inviting me on to, present this information, this valuable information to the community in general. I think a lot of people don't know a lot about probates, and if I can in any way help them answer some of these questions, give them general information, I would absolutely love to do so. And I think this is a great way to do it.
Great. Thank you so much. And um, by the way, this is a live stream video. If anyone have any question about probate, feel free to feel free to either publicly put a comment in the live stream video, and I can inform the attorney about your question. If you want private message me the question, it is okay as well, because sometimes maybe it has the personal information and you don't want to disclose that. That's totally fine. You can private message me, and I can raise the question to Lung as well. Why don't we give a brief introduction about what a probate is, so that everyone can have the basic understanding of what it is.
Sure. Um, so probate is basically the process in which the decedent asset that are not automatically transferred at death to the rightful heirs by non-probate transfer are retitled to the heirs or devisee via court process. Now that might sound a little complicated, but essentially it involves the court, and once you file the probate application, the court grants you the power, or the person represented the power, to then liquidate the assets of the decedent and then distribute it to the rightful heirs of the estate. And it involves whether you have a will or you don't have a will, and there are different rules depending on which one it is. And there's a different type of probates too, like informal versus formal probate.
Got it. Now, so if they have a will, do they have to go through the entire probate process?
Yes, depending on the asset. So how you determine probate is if there is a particular asset that has to go through the court system. So in Arizona, the law is this: if you have personal property, that could mean anything. That could be a bank account, that could be a retirement account, that could be a piece of artwork. If it's value over $75,000, and if it doesn't automatically transfer to the beneficiary, either through like a TOD, transfer on death, or beneficiary designation, in order to transfer the title, you have to go through probate. And then also the second rule is if you have a real property, which is like a house, a piece of land that is worth over $100,000, if that doesn't automatically pass because you didn't do a beneficiary deed, or if you didn't have it in trust, then it also needs to go through probate.
Ah, I see. Even if they have the will, they have to go through. If the value is higher than, like you said, real property, total real property. I guess if they have multiple houses, the total of everything is greater than 100,000, then they have to go through the probate process.
That's correct. So, for example, if you have a will, let's say you create a will and you say, I want to give my house to my children upon my death, right?
Okay.
However, the title on your house is in your name.
Oh.
You haven't done anything to allow it to transfer automatically to your children. All you did was you wrote up a will, and that's not good enough to transfer title. So
Uh,
the will do help though. So when you initiate probate, You submit the will to the court, and the court will allow the personal
Mm,
representative to transfer the house over to the children at that point.
I see. I see. So the will, it just gives the instruction to the church to follow, to transfer the title to my children. But like you said, if I don't do something to the title when I'm still alive, the probate process is still a must
That's
to
correct.
transfer the title.
And there's
I
really only two ways to avoid that. The first way is to do a beneficiary deed for any real property that you have. And the second way is to put it into a trust.
ah
Mhm.
yeah, and a trust is more benefit, I assume.
Correct. Generally, a trust is better than a will because it has like protection for the beneficiary. Um, any kind of asset can be placed into a trust, including asset from another states. Talk about another states. If you own property, which is very common now in Arizona because we have a lot of people moving from other states, New York, California, for example. If
Okay.
you move here and you don't have your estate plan in place and you buy a property here in Arizona, if you suddenly pass away, you not only have to do probate in Arizona, you also have to do probate in California and New York. Each one of those are separate. You have to hire a separate attorney, separate court costs, separate fee. It can tantamount to a lot of probate fees.
Right. Right. The living just gonna help avoiding anything that, right? Because you can add all the properties in all over the countries to one living trust.
That's right.
Oh, okay. That's cool. There's one question from an audience asking about what is the length of the regular probate case if they don't have a will.
So probate in Arizona typically lasts 6 months to a year. Six
Oh,
months
wow.
is the quickest you can close a probate because once you initiate the probate, you have to get the approval from the court to appoint the person representative. After that, you have to collect all the asset for the estate, and then you have to publish in the newspaper and wait 120 days for any potential creditors to come out and assert their claims. So it could
Oh,
be a family member who, before the decedent died, borrow some money. It could be credit card. It could be mortgage company. Essentially, anybody that you owe that the decedent owe money to.
okay. So 6 months to 18 months, you said, or 12 months. Sorry, I
Uh,
missed that.
I say the minimum is 6 months. I mean, probate can last as long as it needs to.
Oh,
Of course, there are contested probate have lasted over 2 years. I know in California, I heard that the typical probate lasts about 2 years.
oh, wow. So what is the general? I mean, there's gonna be a lot of detailed steps into that, but can you give a very high level process of the probate?
Sure. So I prepare a little bit of the steps in probate. So let's see. So the first thing in probate is the family member has to identify the assets of the deceased. And then that's, for example, house, car, bank account, retirement account, business stocks, bond, etc.
Hmm.
After that, the family member has to identify the debts and creditors of the deceased, locate the last will and testament if there's any, and then prepare the application for probate. Um, that can be done through an attorney office who help prepare the application, but I know there are people out there who try to do it themselves. Um, and then after that, once the probate is open, it's the duty of the personal representative to notify all unknown creditors and then
Oh,
do a publication in the newspaper once every week. And then you wait for 4 months for any creditors to assert their claims. Uh, the personal representative has to also open a bank account for that state because that's where you collect all the asset, you liquidate. Liquidate meaning you sell, like you have a piece of artwork, you sell it, you take the money, you put into the estate bank account. Mhm. And if you have any property that you don't know the value of, you have to hire an appraisal. Let's say you have some gold coins. You need to know how much those gold coins are worth. If you have a house, you need to know what's the current market value of the house. So part of the personal representative has to do is also prepare a detailed inventory and accounting of everything that they've collected from the day of death. And, they pay the statutory allowance, meaning if there's a surviving spouse, you have to pay a certain amount of money to keep the surviving spouse, maintain, their basic needs.
Okay.
And then after the 4 months, then you pay taxes, you make sure you pay off all the creditors. Then finally, after you've done all that, then you can distribute the asset to the beneficiary, whatever's left.
Ah, I see.
So in some cases, if the creditor's amount is too high, there's possibly might not be anything left for the beneficiary.
I see. That's unfortunate if we go through the whole process and there's nothing left to the heirs or the people still remaining, right?
Right. And then you close
But
out the probate then.
right, but I guess that explains why the probate process takes very long, because it's involved a lot of notification to the public to make sure that all the creditors have a chance to be informed of the situation and get the credit back, right? From
Yeah.
the decedent.
So people wonder why the need for probate, right? Why make it so complicated? But it's needed because the court wants to provide a legal avenue um, for claim and challenges to be heard. Because after someone passed away, if you are creditors, you want to make sure you get paid. Or if
Mm-hmm.
you are a child or a surviving spouse, you want to make sure that you get your share. Because there
Mm-hmm.
are situations where one person in the family might hoard all the assets and refuse to give it to other people. Say in
Mm.
a family of 5 kids, one kids have a power of attorney, have access to all the bank and information, decide to withdraw all the money and keep it to himself or herself, and
Oh.
the remaining kids don't have anything.
Oh, wow.
And so there needs to be an avenue for the remaining children to assert their claim and get that money.
Right, right. Oh, wow. That's a very unique situation, I guess. What about other examples that you can have, like very unique situation you may give to the audience?
Sure. So let me see. So when I first started, there was a case about, between mother and stepchildren. Now this happened quite often because nowadays a lot of people, they get remarried, right? You were married once, you have kids, and then you get divorced, and then you get remarried. However, when you remarry, you have your own kids, and then your husband also have his own kids.
Oh.
In instances like that, you have stepchildren involved. So those are a little difficult because by law, generally the default rule is that the surviving spouse gets everything, right? However, if there's stepchildren involved, the law do protect the stepchildren from the stepmother or the stepfather from preventing them from getting anything. So the
Uh,
stepchildren in this case are entitled to get a portion of their estate.
oh, wow.
Hmm.
And then for that reason, we have to go through a probate process to
Right.
make sure that everyone involved um, to the properties can get some distribution, right? To a fair distribution to everyone.
Right. So the case I had was a little tricky because it was the mother who um, who inherited this house, but then she wants to live in the house because the husband bought it when it was cheap, and so when
Hmm.
he passed away, the monthly payment is very cheap. However, when she wants to keep the house, it was not allowed by the court. The court forced her to sell the house and divide the house and give the shares to the remaining children. And
Wow, that's
then,
unfortunate for the mother, because obviously she wants to keep the house, but in this unique situation, she has to share with all the stepchildren.
yeah, it's an unfortunate situation where when the husband was alive, he didn't do the estate plan properly to
Oh,
make sure he protected the surviving spouse. So when the husband passed away, the stepchildren comes in and they want their share. So obviously, by law, they're entitled to it.
so I thought that in Arizona there's a community property, right? So I don't know if that is a situation
Um,
that.
so in this case, the husband, he bought it as his sole and separate property.
Oh, I
And he
see.
had a disclaimer when he first bought it so the wife cannot make a claim to the house.
Oh, I see. For those of you who are not aware of what a community property is, that is Arizona law, saying that if the title is in under community property, if one spouse passed away, the remaining spouse is gonna own the entire property under their name, right? There's nothing need to be done for title or anything like that. So it's very convenient for the remaining spouse. But in this situation, to learn that the husband didn't do that way when he's still alive, and therefore it has to go through the probate process and involve all the people that have the right to claim on the property.
That's right.
Yeah.
Generally, if as married couple, I recommend they do, when they get the house, they do a deed that has joint tenancy with right of survivorship. That way,
Oh.
if one spouse passes away, the other spouse automatically gets it.
Hmm.
However, you have to weigh the pro and con too, because let's say if you do have children from a prior marriage, by
Right.
doing such a deed, you are automatically disinherit them from the house.
Hmm.
So the plan and the decision has to be made at the beginning when you do these kind of deeds.
Right. You are right. Is in general community property with right of survivorship is a recommended way, but in some situation, like you said, if you have your own children, then you may not want to take that title and perhaps clarify everything in the living trust, right? And so that it's clearly defined which part of the property is going to belong to whom
That's
when
right.
you pass away. Okay, cool. It's a very good example that you give up. Um,
I have another one too. Just show how the disadvantage of probate. There was another case that we are working on. It was a case taken over from another firm. When they started the probate, there was also stepchildren involved, and obviously it was a contested probate between the surviving spouse versus the stepchildren. And just in the initial phase, the attorney fees was over $10,000 already. So
wow.
the cost was quite high, and even then they couldn't resolve everything. So then the surviving spouse, came to us to help because the first firm couldn't resolve everything. Now, when they came to us, we were able to work it out with children, get a lot of
Mhm.
things knocked out, but the probate is still not done yet, and it's been going on for more than a year, possibly 2 years now. And I can't even imagine at the end of the day how much fee is going to be. However, we did manage to get the court to agree that both sides will cap the fee because if we just keep it running, it will eat up the whole entire estate.
Right.
Mhm.
It doesn't make sense if we go through the entire process and the remaining money is used to pay fees, right? So
Right.
that's fair. Yeah, yeah. Well, I think that is a very good point because a lot of people like setting up the living trust is too expensive. It's cost me like 2 or 3 thousand to do so, you
Mhm.
know. And then they end up have to go through a probate process in which they actually pay more in fee, right? So yeah, that is a very good point that you have there.
Either that or they try to do DIY. Recently, I posted on my Facebook a story about a DIY story, which means do it yourself.
Uh-huh.
That they attempt to do the document themselves. I do not recommend that because, at the end of the day, if you do it wrong, you still have to come to an attorney. And that's where the attorney really make their money is when people make mistakes, not when they're preparing these documents.
Right.
hmm And I'm sorry, I'm not trying to say that's how I make my money, but the work involved, the court fees and all that, that's where all the money comes out.
Right. I know that there's a lot of website that provide like a form template, and then we can go in, enter the information, and then they generate a document, a quick claim deed, for example. And it's very cheap as well, right? And then you can just record to the county. But sometimes the template is not generate correctly, all the information you enter incorrectly, then the deed is not valid anymore, and it's even cost more later on.
Yeah, and that's another cost to it too. So a lot of people do not know about this thing called step-up basis, but step-up basis is where, let's say, I buy a house, right, for $100,000, and then later down the road it appreciates to about $1 million.
Mm.
Now, if I wait until I die and then pass it on to my children upon death, my children gets the new step-up basis of $1 million, meaning they don't have to pay any taxes,
Right.
right? But if during my lifetime I decided I want to deed the house to my son before I die, they don't get to claim that basis. They have to pay the tax on the $900,000 gain on that property, and that happened quite. Now, this is a real scenario, but this happened in California where a lot of Vietnamese parents tend to deed the property to their children to avoid probate or to avoid going to an attorney altogether because it's a cheap way to do it.
Mm.
But then they do not realize that when their children sell their house, that's when they pay the capital gain.
Right.
Minimum, you're talking about 15%. Now take $900,000, multiply by 15%. That's
Right.
a lot of money that your children's gonna be paying in taxes that could have been avoided, right?
Yeah, obviously. Yeah, I think in all situations, I mean, there's some cheap and easy way to do it, but it's end up costing more if you use through a living trust to avoid anything like that, to avoid the probate, to avoid tax increase in the future.
Yeah. Let me
Yeah.
just do a quick analysis of what 15% would be. That'll be $135,000.
Oh, yeah, compared to 10,000.
But 15% is me saying that's the minimum for capital gain.
Right.
Depending on your state, it could be more. It could be 20%.
And it could be depend on your income as well, because the higher your income, the more capital gain tax you have to pay.
That's right. So each percent increase is a lot of money.
Yes, exactly. Well, thank you so much, Lung, for giving us all the useful information and use all the example. For everyone who watched this recorded, this is going to be recorded, and everyone who watching this, if you have any questions regarding to probate, feel free to privately message me. I'll send it over the comments, and we will talk about those questions in next show, which is going to be happening the last Friday of every month. So come back here next show to get more answer and to get more real life experience about the probate. Alung, do you have any last talk to the audience?
Yes. So in case the people don't know, I've been practicing for about 8 years now. And I just opened my office within the last 2 years. I've always been working for, big firm and stuff like that. But upon the 6th year, I decided if I want to serve more like the local people, the Vietnamese community and all that. That's why I decided to open my office. And so if you just want consultation, you just want information, call me. I don't charge for estate planning consultation, and you are welcome to use that information to do what you need to with it, whether you need to go to another attorney, we charge less or whatever you need to. I'm always there, and I want to give as much information as I can to help the community.
That's awesome. Thank you so much. And thank you everyone for watching. Again, if you do have any questions, feel free to privately message me or put a comment, and we will make sure that we get your question answered. Thank you everyone, and
Thank you.
see you again.
Thank you, Long.
Bye-bye.